audit or complaint number X 2022-56. This report is based on a routine audit opened on May 10, 2022. The audit identified deficiencies in the areas of trust accounting, including commingling of broker funds and negative ledger balances, trust account labeling, commission and attorney prepared forms, conflict of interest and license status disclosures, listing contracts in writing, and transaction file requirements. The broker has corrected many of the items as of the date of the commission report. Possible violations include 12-10-2171I, converting, diverting, commingling funds, 12-10-2171M, violation of any commission rule. Rule 5.2, money belonging to others must be deposited in trust or escrow. Rule 5.10, commingling prohibited. Rule 5.14, record keeping requirements. Rule 6.17, duty to disclose conflict of interest and license status. Rule 7.1, standard forms. Recommended disciplinary action includes diversion, a fine of $1,000, and coursework and contracts. I did want to update the commission as well. We received an update from the broker just yesterday on their status with updating or complying with violations or possible violations that were cited in the audit. And it does appear that as of yesterday, they've basically addressed every item in the audit that was identified. And myself and Robert Skinner are here to answer any questions you may have.
Great, thank you. Any discussion on this case? Seeing none, may I get a motion? Renee, you're muted.
I move that in commission matter A, that we accept the recommendation of diversion and a fine of $1,000 plus coursework and contracts.
Thank you. Do we have a second?
Second.
Thank you, Joe. Any further discussion? All those in favor?
Aye.
Aye.
Any opposed? Motion passes as presented.
All right, next is investigative matter B. This is complaint number 2022-1992. On October 17, 2022, the respondent was convicted of 1, assault in the second degree, a class 4 felony, and 2, assault in the third degree, a class 1 misdemeanor. The respondent entered into a 2-year deferred judgment and sentence of count 1 only with 2 years probation. Count 2 will remain on the respondent's record. Possible violations include 12-10-2171N, conviction, plea to specified crimes. Recommended disciplinary action includes diversion, a fine of $250, and I can answer any questions you may have.
Thank you. Any discussion on this case? Questions?
Is it still on probation now currently or not?
Yes.
Don't we normally do something concurrent with the probation on ours to probation with his?
No, not necessarily. I don't think that's a standard. Typically what we do is a $250 fine per violation and stip for diversion. And in this case, the respondent reported the criminal conviction to us. So it's just the violation of the conviction of the crime.
Okay.
We've definitely seen it, Renee. I think it's more of the severity probably of what has happened. We have any other questions or comments? Hearing none, may I get a motion?
I motion that in commission matter B, that we approve the recommended disciplinary action of diversion and a fine of $250.
Thank you. Do we have a second?
Second.
Joe, any further discussion? All those in favor?
Aye.
Aye.
Any opposed? Motion passes as presented.
All right, your next item is investigative matter C. This is audit or complaint number X 2022-104. This is a respondent's second follow-up division audit based on two previous stipulation for diversions in 2020 and 2021. Findings in the previous audits included lack of supervision and proper management of money belonging to others, included diversion of money and missing journal reports, missing disclosures, non-compliant real estate forms, and failure to adhere to license law and commission rules related to the advertising of the brokerage's property management business. All these prior deficiencies were the result of the respondent permitting an associate broker to operate a separate and unsupervised property management company. The respondent was able to achieve compliance over the course of the follow-up audits. The present audit found a new issue related to the respondent's lack of supervision. The associate broker referenced above continued to perform property management services, including signing approximately 10 real estate documents, including leases, management agreements, disclosures, throughout the 9-month period of time the associate broker's license was inactive. Possible violations include 12-10-2171M, violation of any commission rule, 12-10-2171R, failure to supervise associates, and Rule 6.3, employing brokers' responsibilities and supervision. Recommended disciplinary action includes a letter of concern with dismissal, and Auditor or Investigator Jay Saul is here to answer any questions, or McLean and myself.
Thank you.
I had a question on this one. If there are still ongoing issues with supervising, shouldn't the recommendation be a little harsher because there's still issues going on with supervision?
There is an issue that was identified in this case with the associate broker having an inactive license and continuing to perform real estate services. It appears that's more of an issue with that associate broker, which you'll see their case next. So we felt this was fair for the employing broker, but if that's something the commission thinks should be different or changed, that's up to y'all to decide.
Renee, what are your thoughts there?
No one else has comments? No one else sees issues. Well,
I think. Go
Sorry,
ahead.
Michelle. Commissioners, I'll just make a comment that typically the commission doesn't look at the liability on the part of the supervising broker when there's an associate broker who is operating with an inactive status. That's something that you might want to keep in mind. However, this case might feel different to you. And as Eddie said, the decision is yours whether you want to change the recommended discipline.
I guess, Renee, I'd like to hear a little bit about maybe what you think an appropriate recommendation would be.
they've corrected everything at this point? Is that correct?
The audit, all the original audit deficiencies that were cited in the first two audits do appear to be corrected at this point in time. So it really was this issue regarding the associate broker's inactive license. Yeah.
Okay, I guess we can just address that one next.
Any further questions or discussion? May I get a motion?
Sure. In investigative matter C, I move that we have approved staff's recommendations of a letter of concern or dismissal.
A second?
A second.
You, Joe. Any further discussion? All those in favor?
Aye.
Aye.
Any opposed? Motion passes as presented.
Right, your next item is investigative matter D. This is complaint number 2022-1711. This complaint was opened as part of an audit on the respondent's employing broker. The audit investigation found that the respondent had an inactive real estate license for a 9-month period during 2022, which time the respondent acted as a licensed broker, performing property management services, including the signing of approximately 10 real estate documents, including leases and management agreements and disclosures. Possible violations include 12-10-217-1M, violation of any commission rule, Rules 3.9, errors and omissions insurance, Rule 6.26, actions when license is suspended, revoked, expired, or inactive. Recommended disciplinary action includes diversion and a fine of $1,000. And again, Auditor Jay McLean is here to answer any questions you may have.
All right, questions? Comments? Nothing. May I get a motion?
I motion in a complaint 2022-1711 to accept the disciplinary action of diversion and $1,000 fine.
May I get a second?
Second.
Second.
Any further discussion? All those in favor?
Aye.
Aye.
Any opposed? Motion passes as presented.
Good morning.
Good morning.
The next is investigative matter E, complaint number 2022-1362. On July 19th of 2022, the respondent entered into a guilty plea in the El Paso County, Colorado District Court to sexual exploitation of a child, a class 3 felony. On December 20th, 2022, the respondent was sentenced to a deferred judgment of 90 days in jail, suspended, pending successful completion of 4 years of Colorado sex offender intensive supervision probation program, starting on December 21st of 2022. The respondent is required to pay a total of $7,073.50 in court costs and fees and must register as a sex offender. As of February 6, 2023, there is a remaining balance of $7,073.50. The division was notified of the guilty plea by a CBI report. Possible violations include 12-10-217-1N, conviction, plea to specified crimes, 12-10-217-1P, failure to immediately notify CREC, 12-10-217-1M, violation of any commission rule, and Rule 6.23, immediate notification of conviction or plea. We do not have a disciplinary recommendation on this one. Typically, it's $500, $250 for the crime and $250 for not reporting. But we thought this might warrant a different, since it's a different case in nature, it might warrant some discussion by commissioners.
So I have a question. The respondent's been inactive since 2019, is that correct?
That's correct.
So is it after 3 years they have to reapply? If it's been inactive for over 3 years?
No, Madam Chair, they can be inactive for forever as long as they just renew.
Okay. All right, any discussion? I guess I will look for some guidance on what we,
Right.
this person has been gone has been inactive for so long. What is within our parameters to do to have them actually reapply or make it to where we would have to see this respondent again before we let them have an active license? Does that make sense?
So they would have to, I mean, you could put a restriction on there that they couldn't go to inactive status without your approval, which we're going to have to put kind of a hold in the system. And I don't know that we've done anything like that before. So, I mean, we definitely have to work with Angela on the wording for a stipulation because that's something they'd have to agree to. But I'm sure we could figure something out.
I don't know that we have done that before, but I can say that there have been some other cases in the history of the commission where when someone is required to be a registered sex offender, that the commission has gone for a revocation.
Okay.
And with that, would a revocation, do you think be, I mean, I guess, has it sort of been uniformly applied that we go for revocation, or there's already sort of gray area there? I just want to make sure that, we're handling this, appropriately and correctly.
So I don't think it's an automatic that every time somebody has kind of a sex-related offense that it's a revocation. I think you guys have to base it based on the facts and what you consider to be the appropriate level of discipline, which is kind of one of the reasons that we didn't make a recommendation, is we just didn't know, given the circumstances, how you guys would feel about this.
Okay.
So
Sorry, go ahead.
if there is a revocation, the respondent could still apply apply for a license, but that would come before the commission.
So there would be a 2-year period after they were revoked where they couldn't apply. Then they would come back and you would see them because they'd had the prior license discipline.
I think that's a 1-year period, Marcia.
Oh, sorry. It's not as permanent as the statutes make it sound.
But bottom line is they would have to come back to us before
Correct.
they could get a license. And I think for me, ultimately, that's what I would like to see. The end result is that they would have to come back before us to have an active license.
Agreed.
So I guess that would make a motion of revocation. Can we get a motion? Is someone comfortable making a motion for that?
I will. In complaint number 2022-1362, I motion for revocation.
Do we have to do public censure and fine with that, Angela?
So you don't have to do anything. This is your decision of the discipline, but typically a revocation is accompanied by a final agency order, public censure, and a maximum fine, which in this case would be 3 violations at the maximum of $2,500 each. Someone do the math for me.
7,500.
Yeah.
Well, I definitely think final agency order and public censure should go along with that revocation. Maybe not necessarily the fine. That's,
Yeah.
I agree with that.
do you mind amending your motion, Joe?
Sure. I motion in complaint number 2022-1362 for disciplinary action of final agency order, public censure, and revocation.
Thank you. Do we have a second?
Second.
Thank you, Graham. Any further discussion? Motion passes for final agency order, public censure, and revocation.
The next is investigative matter F, complaint number 2022-255. The complaint alleged that the respondent is providing an MLS entry-only service to home sellers using non-CREC approved forms and failing to provide minimum duties. The investigation found that the respondent was using non-CREC approved listing contracts, disclosures, and failed to provide minimum duties required as a transaction broker. Additionally, the respondent's transaction files were incomplete. Possible violations include 1210-407, failure to provide minimal duties, 1210-217-1K, failure to maintain files for 4 years, 1210-217-1M, violation of any commission rule, 1210-217-1Q, unworthy incompetent practice, Rule 7.1, standard forms, 6.11, square footage disclosure, 6.19, closing responsibility, 6.2, competency, and Rule 6.20, transaction file requirements. Disciplinary recommendations include final agency order, public censure, coursework in 48 hours of coursework in real estate law and real estate practice, 48 hours of coursework in contracts, a fine of $10,000, license downgrade to an associate broker for 2 years and must reapply for an employing broker, and also a direct referral to the AG because they have a pending case. And investigator Dersvix can answer any questions that you might have.
Morning.
Good morning. This is third. Is this the third issue with this broker? That's what I'm seeing.
I
Well,
believe I'm aware of the one that's referenced in the report, the prior case from 2021, I believe. We can certainly take a look.
I think it said it was the third complaint.
I think we've got 2008, 2020, and then now this is the third.
I apologize. You're correct. I apologize. That is correct. There was a complaint back in 2000.
Okay, and it's all pretty much for the same thing.
So I can't speak to the one in 2008 just because of the documentation that has been destroyed, with the exception of just the basic outline of what the complaint matter was about to begin with, which appears to be the limited services situation as well.
Okay. And looks like license expired 12/31 in 2022. Did this broker are they still licensed or are they on inactive?
I
Did they
can take a
renew?
look at that right now. Sorry about that wait. It does appear that it's expired as of 12/31/2022, based on what I can see. I'm not sure if someone in slightly more familiar with licensing situation could maybe chime in if there's something different I should be aware of.
But even though they expired a little over a month ago, they've got reinstatement rights and they can reinstate for 3 years following the expiration. So you still have jurisdiction over their license.
Okay. I would also like to see a suspension on this license. Anybody else have any questions or comments?
I mean, I would second that idea of going for a suspension in this matter.
I mean, 3 times, that's quite just, I don't know. Flagrant. Just, we get a motion.
So in the matter of commission matter F, recommend to go with disciplinary recommendations of final agency order, public censure, fine of $10,000, coursework of 48 hours real estate law, real estate practice, coursework 48 hours of contracts, and license downgrade to FA for 2 years, must reapply for ER, and also a suspension of 2 years.
Do we have a second?
Second.
Any further discussion? Motion passes as presented with the addition of a suspension for 2 years.
I'm sorry, I didn't hear the vote.
Oh, I apologize.
I heard the second, but not the vote.
You're right, Angela. Thank you. All those in favor?
Aye.
Aye.
Aye. Any opposed? Now motion passes as presented with the addition of the suspension of 2 years.
Okay. Just one second. Okay. The next one is matter G, complaints. There's 3 complaints that are combined. 2021-2149, 2022-1192, and 2022-1149. A complaint for 2021-2149, the summary is: a complaint was filed by the listing agent of a property alleging that the respondent presented a contract which failed to disclose the fact that the buyer's ability to qualify for financing was contingent upon the sale of their current residence. The complaint also alleged that the respondent failed to notify the listing agent of the buyer's changing lenders late in the process and failed to provide an updated lender letter. The transaction file reflects that the respondent failed to update the contract to buy and sell after her clients changed lenders. The respondent was identified as the buyer's agent in the contract to buy and sell, but her transaction file did not contain an executed listing agreement. 22-1149 summary is: the complainant alleged that the respondent failed to provide the title company an amend extend to the contract to buy and sell that called for a $1,000 seller credit to the buyer, resulting in the complainant not receiving the $1,000 credit at closing. The complainant was later made whole by the seller. Respondent did not ensure that there was an accurate closing statement, failed to provide the commission all requested documents, and failed to provide the buyers a brokerage disclosure to buyer form. Complaint 2022-1449. The summary is: respondent failed to provide the commission a written response to the complaint and the requested documents. Possible violations include 2 counts of 1210-217-1K, failure to produce documents, 1210-217-1M, violation of any commission rule, 1210-408-2C, failed to provide customer proper disclosures, 1210-217-1Q, unworthy incompetent practice, 1210-405-3A, single agent for buyer, failed to disclose material fact, Rule 6.25C, failed to produce requested records, 6.19C, closing responsibility, 6.5, brokerage relationship disclosures in writing, and Rule 6.25, failed to submit written response to the complaint. Disciplinary recommendations include public censure, a final agency order, coursework in contracts, coursework in brokerage relationships, coursework in ethics, a fine of $9,000, and a license downgrade to associate broker. And Investigator Martinez can answer any questions that you might have.
Thank you. Questions or comments on this case?
With the recommendation of license downgrade, is that permanent? Or do we have to define that, the period of time, I guess?
So we should probably define a period of time.
Okay.
Any further discussion? May I get a motion?
I'll motion in investigative matter G to accept disciplinary action of final agency order, public censure, fine of $9,000, coursework in contracts, brokerage relationships, and ethics, and a license downgrade to associate broker level for 2 years and must reapply for employee broker level.
Second.
Thank you. Any further discussion? All those in favor?
Aye.
Aye.
Any opposed? Motion passes as presented with the license downgrade of 2 years and must apply, reapply for ER status.
The next is investigative matter H, complaint number 2022-1930. The respondent admitted to the allegation that she provided her buyer client with the lockbox code to gain entry into a property that was listed for sale. The investigation noted that the respondent's husband, who is also a licensee, accompanied the buyer. Possible violations include 1210, 217-1M, violation of any commission rule, 1210, 217-1Q, unworthy incompetent practice, and Rule 6.16, access information. Disciplinary recommendations include diversion and a fine of $500, and investigator Geske can answer any questions that you might have.
Thank you. Any questions?
Do we know why the client was given the lockbox if the husband who's licensed was there?
And she was a personal friend of the broker.
Okay.
Any further discussion? Questions? May I get a motion?
In commission matter H, I move that we accept staff's recommendations of diversion and a fine of $500.
May I get a second?
Second.
Any further discussion? All those in favor?
Aye.
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 Any opposed? Motion passes as presented.
Investigative matter I is complaint number 2022-1978. On January 31st of 2022, the respondent pled guilty to a misdemeanor assault. The respondent failed to report his guilty plea to the commission as required. Possible violations include 1210-217-1M, violation of any commission rule, 1210-217-1P, failure to immediately notify STRAC, Rules 6.23, immediate notification of conviction plea, and possible disciplinary recommendations are diversion and a fine of $250. And investigator Gabarty can answer any questions.
Thank you. Any questions or comments? May I get a motion?
I motion that in Commissioner Matter I, we approve the disciplinary recommendations of diversion and a fine of $500.
May I get a second?
Second.
You, Graham?
Sorry, commissioners, I think that recommended fine was modified because it's only a reporting violation. I think Nicole, when she read it to you, changed it to $250 for that reason. Renee, would you, if you agree with that recommendation, would you modify your motion?
I think it's okay as it stands. Any discussion?
Nicole, do you want to just explain the reasoning for the $250 as opposed to $500, and then the commissioners can decide?
Yeah, the 500 is usually for the conviction and also for the failure to notify us. So in this case, it was just half of that.
I thought this one had a failure to report and also a conviction. Whereas I thought this one had a guilty plea and a failure to report.
There's no violation for the conviction in this case because this was a deferred sentence and that deferred sentence has already run. So the conviction does not exist. So the division is not recommending that you impose discipline for that violation. Even though you're correct, Renee, at one point there was a conviction, it is no longer on the respondent's record.
Renee, totally up to you. Do you want to leave it at leave your current motion, or do you want to switch it to 250 to modify?
I'm okay leaving it, but do you guys, you wanting to change it to 250?
Graham, are you okay with still your second?
I mean, I struggle a little bit. I mean, after hearing that, I am okay going down to 250.
Okay, I'll change it then. In Commission Matter I, we're going to do the disciplinary recommendation of diversion and change the fine to $250.
Okay, Graham, you still second?
I still second.
Perfect. Any further discussion? All those in favor?
Aye.
Aye.
Any opposed? Motion passes as presented.
Investigative matter J is complaint number 2022-827. The allegations made by the complainant, who was the seller of the property, could not be substantiated. However, the investigation found that the respondent received an agreement to amend extend the closing date from the listing agent. The amend extend was provided to the respondent's buyer and was executed. The respondent, however, failed to return the amend extend to the listing agent. The complainant subsequently terminated, which led to a legal dispute between the buyer and the complainant. Additionally, the respondent was unable to provide several required documents that should have been signed by the buyer. Possible violations include 1210-217-1M, violation of any commission rule, 1210-217-1Q, unworthy incompetent practice, 1210-4051B, buyer's agent exercise reasonable skill and care, 1210-217-1K, failure to maintain files for 4 years, and Rule 6.20, transaction file requirements. Disciplinary recommendations include final agency order, fine of $2,500, coursework in contracts, and coursework in brokerage relationships. And Investigator Gabarty can answer any questions.
Thank you. Questions?
I'm curious, do we know why, I believe this property fell out of contract 3 times? Do we know why? Was there a reason for any of those?
Commissioners, I'm unsure of that.
Okay. I know that this respondent had some deficiencies in the transaction, the files and documentation. I guess I would just want to say I feel like the complainant or the listing agent had some responsibility in what transpired. It just seemed like there was no upfront disclosure about quieting the title, which I think they would have known from the first time that it fell out of contract. I mean, it was under contract for 3 weeks. And I believe the respondent mentions that they didn't find out about it until after they went under contract. So I think that just set the tone for how this, played out eventually. So I have a little, I guess I have an issue with the disciplinary recommendation of final agency order because of what happened. And I know this is not, the respondent has no prior, stipulations or violations. So that's where I'm at.
So what are you thinking as far as discipline? I mean, because there were still other issues that are warranted.
I know,
there.
with the not with the amend extend failure to send that back. I mean, I'm in the thought of diversion, but I mean, I'm open to what the other commissioners think, and if they think that final agency order is warranted, I'm okay with that too. I would tend to motion towards diversion in this case.
I would agree with Joe.
After that long-winded speech.
All right. Well, then, Joe, would you like to make a motion?
Okay. In investigative matter J, I motion for disciplinary action of diversion, fine of $2,500, coursework in contracts and brokerage relationships.
Do we have a second?
Second.
Thank you, Renee. Any further discussion? All those in favor?
Aye.
Aye.
Aye. Any opposed? Motion passes for diversion, a fine of $2,500, a coursework in contracts, and a coursework in brokerage relationships. This next case, I do need to recuse, so I'm going to leave the meeting. And Angela will let me know when it's good to come back in.
Yes, thanks, Michelle. And Graham, as vice chair, do you mind taking over for the next matter, which is we've skipped one on the agenda and then we move forward to, I think it's L.
L, okay. All right, is there do I need a script or anything, or? Okay,
The team lead will introduce it and then you will just shepherd the discussion after that point.
okay, sounds good.
Investigative matter L is complaint 2022-1950. On November 21st of 2022, the respondent pled guilty to sexual contact, no consent, a class 1 misdemeanor. The respondent was ordered to complete 2 years of supervised probation and pay $1,976 in court costs. The court costs have been paid in full. Possible violations include 1210-217-1N, conviction, plea to specified crimes. Disciplinary recommendations include diversion, a fine of $250, probation to run concurrent with the criminal sentence, and a license downgrade to associate broker while under probation. And investigator Peters can answer any questions.
Do we know when this was actually disclosed to the commission? Or the division?
Yes, I remember that it was disclosed within, let me see here. So the conviction was on September 15th, 2022. The respondent disclosed the conviction to the division on September
The
21st,
Okay,
2022.
so that disclosure is good, even though sentencing wasn't until November, so we're good there with disclosure, right?
Correct.
Any discussion, any further questions?
No.
All right, may anyone have a motion?
I motion that in commission matter L, that we approve the disciplinary recommendations of diversion, a fine of $250, probation to run concurrent with a criminal sentence, a downgrade to FA while under probation.
Do we have a second?
I second.
Thank you, Joe. Any further discussion? All right, all those in favor?
Aye.
All those opposed? Seeing none. Staff's recommendations in matter L have been approved.
Give me just a moment, commissioners, to get Michelle back on the platform and we'll pick up on the agenda.
All right, I am back. All right, are we on matter M now?
Yes.
Okay.
Investigative matter M is complaint number 2022-1731. The complainant, who was the listing agent for a property, said that her seller had a video of buyers entering her home without their broker. After viewing the video, the complainant saw the person who entered the home did not look like the broker. The respondent acknowledged that he was running late to the showing and wouldn't make it in time, so he gave the entry code to his buyer. Possible violations include 1210-217-1M, violation of any commission rule, 1210-217-1Q, unworthy and incompetent practice, Rule 6.16, access information, and disciplinary recommendations include diversion and a fine of $500. And Investigator Peters can answer any questions.
Thank you. Any questions? Seeing none, may I get a motion?
In commission matter M, I move that we accept staff's recommendations of a diversion and a fine of $500.
Do we have a second? Thank
Second.
you, Joe. Any further discussion? All those in favor?
Aye.
Any opposed? Motion passes as presented.
All right, commission matter N is complaint number 2022-445. The complainant purchased a property that was listed and owned by the respondent. The complainant stated that the respondent provided her with a previous inspection that had been conducted on the property, of which she relied on to determine the property's condition. The complainant alleged that the respondent did not disclose information from a second previous inspection, which contained issues regarding the structure of the property. The complainant stated that she had to pay $5,500 to correct the known issues with the subject property. Subsequent to the complainant submitting her complaint, the respondent, through settlement negotiations, paid the complainant $5,500. The investigation noted potential violations that the respondent failed to establish his brokerage relationship or lack thereof in writing with two of the potential buyers. Possible violations are 1210-4043A, 1210-4082C, 1210-217-1M, and Rule 6.5. And the disciplinary recommendation is a final agency order, a fine of $2,500, and coursework in ethics and contracts. And investigator Denise Wright is here to answer any questions you may have.
Thank you. Any questions, comments?
This agent has been doing this for a long time, correct? In business for a long time?
I believe so. I can look on the report.
As
2018.
Because he was using the definitions, not the broker relationship. I'm wondering if the fine should be higher, seeing as how this has gone over every year in the ACU.
Commissioners, any other discussion or thoughts on a higher fine? I do have to say, I think that that form, even though it is brought up in the annual update every year, is probably one of the highest misused with understanding forms. I just see it often where people are confused about that form, even though you're right, it does go over it every single year, every year. But I think there is just a lot of, I don't know why they don't get it, those who don't get it. But there is a lot of confusion on that form. So anybody else have any thoughts on the fine or anything like that, or are okay with the discipline that's been presented?
Yeah, I mean, I personally think that the discipline that's presented looks okay. I mean, I understand Renee's concerns, but I do think that in dealing with this form, and as Chairwoman Espinoza discussed, I do have a little bit of some grace here for this complainant or for this respondent.
I will agree with that solely because the respondent did settle with the complainant and did pay $5,500.
So hopefully lesson learned, right?
Yeah.
Someone want to make a motion?
Sure. Madam Chair, in Commission Matter N, I move that we accept staff's recommendations of final agency order, coursework in ethics and contracts, and a fine of $2,500.
Do we have a second?
I second.
Joe? Any further discussion? All those in favor? Aye.
Aye.
Any opposed? Motion passes as presented.
Okay, your next item is investigative matter O. This is complaint number 2022-164. On January 25th, 2022, the Colorado Real Estate Commission opened complaint number 2022-164 against the respondent as there appeared to be a discrepancy on the education certificates the respondent provided compared to what the provider stated the respondent completed. The respondent acknowledges that she filled out the dates on the education certificates and acknowledges that she did not take a course on February 17, 2020, despite not attending a course on that date. The respondent states she did not know how she obtained an education certificate that is dated on a date she admits was not offered, nor did she take. Possible violations include 12-10-2171M, violation of any commission rule, 12-10-2171S, misstatement on license application, Rule 4.5, continuing education requirements. Recommended disciplinary action includes diversion, a $500 fine, coursework in ethics, and 1 hour of coursework for the missing continuing education to complete and comply with the 24-hour CE audit. And investigator Marcy Rivera is here to answer any questions you may have.
Thank you. Questions or comments? Seeing none, may I get a motion?
In Commission Matter O, I move that we accept staff's recommendations of coursework in ethics, coursework for 1 hour missing continuing education to comply with a 24-hour continuing education audit, diversion, and a fine of $500.
We have a second?
Second.
Joe? Any further discussion? All those in favor?
Aye.
Aye.
Any opposed? Motion passes as presented.
Okay, your next item is investigative matter P. This is audit number X 2022-158. Routine audit was opened on the respondent on September 29, 2022, in addition to sub-audits on the respondent's associate brokers that manage their personally owned rental properties. This audit identified potential issues with the respondent's use of non-fiduciary accounts to hold money belonging to others, lack of compliant 3-year reconciliations and accounting of money belonging to others, and lack of written agreements addressing interest earned on accounts holding money belonging to others. Lastly, one of the respondent's associate brokers is holding security deposit funds for her personally owned rental property in an account in the name of the respondent's brokerage. The respondent was not a signer on this account. Possible violations include 12-10-2171H, failure to account for funds received, 12-10-2171M, violation of any commission rule, Rule 5.2, money belonging to others must be deposited in trust or escrow, Rule 5.14, record keeping requirements, Rule 5.3C, employee broker must be named on the account. Recommended disciplinary action includes diversion, $500 fine, coursework and trust accounts, and a follow-up audit within 3 months. And Auditor Betsy Meredith is here to answer any questions you may have.
Good morning.
Good morning. Any questions or comments on this one?
So have these accounts been corrected so that they are now fiduciary accounts?
Like we mentioned in the report, we don't have verification of that, which is.
Is that why the follow-up audit in 3 months?
Correct.
Any other questions? Seeing none, may I get a motion?
I motion investigative matter P to accept disciplinary action of diversion, fine of 100, coursework and trust accounts, and a follow-up audit within 3 months.
Thank you. Do we have a second?
Second.
Thank you, Graham. Any further discussion? All those in favor? Aye.
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 Any opposed? Motion passes as presented.
Okay, your next item is investigative matter Q. This is audit number X 2022-186. This audit was open in relation to a full scope audit on the respondent's employing broker, which is audit number X 2022-158. This account focused on the respondent's broker-owned rental property. During the course of the audit, the broker was holding security deposit for her personally owned rental in a non-fiduciary account in the name of her brokerage firm that her employing broker was not part of. Additionally, she was not performing a reconciliation of the funds. The account was interest-bearing with the interest transferred monthly to Carhoff. However, the respondent did not have a written agreement with the tenant addressing the interest earned, nor did the respondent's lease address the interest. Lastly, the respondent had not provided a broker disclosure to the tenant nor written disclosure of license status and any conflict of interest to the tenant. The respondent corrected all items identified during the audit with the exception of past interest earned in the account totaling approximately $8 that was transferred to Carhoff may actually belong to the tenant. Possible violations include 12-10-217 1M, violation of any commission rule. Rules 5.2, money belonging to others must be deposited in trust or escrow. Rule 5.11, money belonging to others for non-real estate brokerage services. Rule 6.5, brokerage relationship disclosures in writing. Rule 6.17, duty to disclose conflict of interest and license status. Recommended disciplinary action includes a letter of concern with dismissal, which will note the address returning the $8 to the tenant.
So I had a question, just kind of in general, I guess. So, or specific and then in general. So did this respondent just not understand maybe the rules that were required of them?
I think that's the case with most of these sub audits.
So, which leads me to my general then question is when this happens and it comes, when you see this, do they get like a one-on-one, not really counseling session, but, you know, kind of an overview of like how this is really supposed to work so that they don't make this mistake going forward?
Which mistakes specifically?
So like all of us, like the commingling, like, you know, just general property management. I mean, we see so much of it, right, in our cases. So when you have someone like this that's doing it for their own property, when it comes in front of one of the auditors or the investigators, are they given, you know, that guidance of this is how it should work, right?
Well, and so the phrase guidance is tricky, right? Because the division staff does not give practice related guidance. That being said, we always, I mean, I can speak for myself, but I know Eddie runs a tight ship on this. We're consistent. We do provide license law, and we actually provide samples of what a compliant reconciliation look like, a compliant signature card should look like. And we're pretty good about making sure they have license law, but you can imagine what would happen if we had to offer training to every broker.
Right. Okay. Thank you.
You bet.
To answer your question, the brokers are provided with, you know, plenty of resources, you know, including the license law to help them understand what they need to do to be in compliance, in addition to the communication that's, you know, probably going on in between the investigator or the auditor with that individual. So I believe to some extent, I would say yes to answer your question and what you had asked.
Okay, thank you. Renee, did you have any questions or comments on this? You are muted.
So this one deals with the previous one with the fiduciary accounts, and you're doing an audit in 3 months to go back and look at this again, correct? And
So this is a separate issue than the one we just discussed. This particular one is not the account from the current employing broker. This was something that she had carried over, you was using on her personal accounts, which that has now been completely fixed.
So it's now a fiduciary account?
Correct.
Okay. And she's fixed the lease as well? Is that correct? Okay.
Everything has been corrected in the auditor. We'd make sure we'd be following up.
Okay.
Great. Because that's kind of what we want, right? We want it to be a learning experience to make sure they're not carrying these, I don't want to say bad habits, but they're learning it and they're being better,
Certainly.
out of the audit.
Certainly. And we just had the webinar on, the audit process, to help educate the brokers and provide some additional resources that are out there. And we're going to be putting together, we have a newsletter that's been drafted that we're working on to publish for the brokers as well, that will address these kind of broker owned audits and some of the issues and common deficiencies that we're seeing, and provide some additional resource for them to make sure that they're in compliance. But that's what this particular audit that you're looking at right here was really focused on. This associate broker's property management of her personally owned rental, which really kind of focuses on the rule 5.11 and then a couple additional rules that the brokers really need to comply with in regards to this sort of area.
Great. Well, thank you. Yeah. And I appreciate the webinar and the newsletter. The more information we can help these brokers, not get into these bad ways of practice is great. So do we have a motion for this case?
I motion that in Commission Matter Q, we accept the disciplinary recommendations of letter of concern with dismissal.
Thank you. Do we have a second?
Second.
Thank you, Graham. Any further discussion? All those in favor?
Aye.
Aye.
Any opposed? Motion passes as presented.
Right. Next is investigative matter R. This is complaint number 2021-2002. On November 24th, 2021, the complainant filed complaint number 2021-2002 against the respondent, stating that in 2018, the complainant invested $140,000 with the respondent in their Colorado fix and flip company. The respondent's marketing materials provided to the complainant mentioned that the respondent's status and connections as a licensed Colorado real estate broker, and that the complainant's funds would be used for fix and flip projects in Colorado. The marketing materials state that the complainant's investment would be secured with a promissory note and mortgage deed, and that the respondent also told the complainant that his investment would be secured with a promissory note and mortgage deed on a property in Toledo, Ohio. Contrary to the statements and marketing materials provided by the respondent stating that the funds would be used for fix and flip properties, the respondent used the complainant's funds to pay off another second lien investor without the complainant's knowledge or consent. Additionally, the respondent provided the complainant with both a deficient promissory note and mortgage deed. As such, the complainant did not have collateral on his investment. The respondent defaulted on the balloon payment on the complainant's promissory note and then failed to disclose to the complainant that the Toledo, Ohio property was surrendered as a deed in lieu of foreclosure to the first lien position lender. Shortly after the complainant initiated a lawsuit against the respondent filed for bankruptcy, which was approved and lists the complainant as an unsecured creditor because the deficient note and mortgage was never recorded. At least 2 other investors have filed civil claims against the respondent. Possible violations include 12-10-2171A, false advertising, 12-10-2171B, making false promise to influence, 12-10-2171W, dishonest stealing. Recommended disciplinary action includes a final agency order, public censure, revocation, and a fine of $7,500. And Investigator Marcy Rivera is here to answer any questions you may have.
Thank you. Any questions on this case? Hearing none, may I get a motion?
I motion that in Commission Matter R, we accept staff recommendation for discipline of final agency order, public censure, revocation, and a fine of $7,500.
We have a second?
Second.
Any further discussion? All those in favor?
Aye.
Aye.
Any opposed? Motion passes as presented.
Investigative matter S is complaint number 2022-247. On February 9th of 2022, the Division of Real Estate received a complaint against the respondent regarding property management and billing practices in a large apartment complex in Broomfield, Colorado. The respondent is an employing broker of the Colorado licensed brokerage involved solely in property management, currently managing a property approximately 15,000 residential units in Colorado. The respondent is the only licensee with the brokerage. The investigation found that the respondent's property management agreement and lease were not compliant and that the brokerage billed tenants on the owner's behalf for common area maintenance charges without supporting documentation and adequate accounting. Additionally, the respondent did not provide a brokerage disclosure to tenant form to the tenant. Possible violations include 1210-217-1Q, unworthy incompetent practice, 1210-217-1M, violation of any commission rule, 1210-217-1K, failure to maintain files for 4 years, Rules 5.14, record keeping, 7.1, standard forms, and Rule 6.5, brokerage relationship disclosures in writing. Disciplinary recommendations include diversion, a fine of $750, coursework and contracts, and an audit within 3 months. And Investigator Jurcevics can answer any questions.
Thank you. Questions? Comments? Seeing none, may I get a motion?
I motion that in commission matter S, we accept the disciplinary recommendations of diversion, fine of 700. Oh, wait, am I on the wrong one? No.
No, you're on the right one.
Oh, I'm sorry. I misread this. I thought the fine was, so I guess I'm going to have discussion then. I think the fine should be increased. This broker has prior history of stipulation and there are multiple issues going on. I think the fine should be increased.
Okay. And what do you think would be a fair amount for the fine?
No. I would say a minimum of 2,500.
Commissioners, discussion?
There are issues with the disclosures to the tenant. There's issues with the PMA, and there's a prior stipulation.
Right, from 2020.
Yep.
So you're proposing a fine of 2,500?
Yes.
All right, would you like to
Okay, amend it.
amend your
Right,
motion, please?
Okay, in the matter of commission matter S, disciplinary recommendations of diversion, fine of 2,500, coursework and contracts, an audit within 3 months. That's what recommend for approval.
We have a second?
I'll second.
Any further discussion? All those in favor?
Aye.
Aye.
Aye. Any opposed? Motion passes of diversion, a fine of $2,500, coursework and ethics, and an audit within 3 months.
Investigative.
Sorry, I think the coursework was contracts, wasn't it?
Oh, I'm sorry. Yes, coursework and contracts.
Thank you.
Investigative matter T is complaint number 2022-905. The complainant and her husband were the first-time homebuyers represented by the respondent in the attempted purchase of the subject property. The complainant alleges that the respondent did not discuss with her and her husband that their contract to buy and sell did not provide an inspection objection in an inspection resolution deadline, which resulted in the loss of their $5,000 in earnest money. There was insufficient evidence to prove this allegation. The respondent failed to disclose brokerage relationships prior to obtaining confidential information from the buyers. The respondent failed to complete an agreement to amend extend the contract prior to the inspection termination deadline to protect the buyer's earnest money deposit, while issues regarding the roof were resolved with the seller. Possible violations include 1210-217-1M, violation of any commission rule, 1210-217-1Q, unworthy incompetent practice, and Rule 6.5, brokerage relationship disclosures in writing. Disciplinary recommendations include diversion, a fine of $1,000, and coursework in contracts. Investigator Gabarty is here to answer any questions.
Thank you. Any questions? Any discussion? Seeing none, may I get a motion?
In investigative matter T, I move that we accept staff's recommendation of coursework and contracts, diversion, and a fine of $1,000.
Thank you, Graham. Do we have a second?
Second.
Any further discussion? All those in favor?
Aye.
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 Any opposed? Motion passes as presented.
All right, investigative matter U is complaint number 2022-1367. The division received a complaint filed by an attorney on behalf of his client. His client purchased a home from a seller who had entered into a quote, homeowner benefit agreement prior to selling the home. The previous homeowner received $835 in exchange for a 40-year agreement to exclusively list the home for sale with the respondent. A memorandum of the HBA or home buyer benefit agreement was recorded against the property. When the home sold and a quote early termination fee was not collected from the previous owner, the respondent contacted the buyer in an attempt to collect $8,395.50. The respondent, through their attorney, stated that the buyer was now responsible for the early termination fee. The respondent stated through their attorney that if the early termination fee was not paid by the buyer, the respondent would pursue a judicial foreclosure. A brokerage duties addendum completed in conjunction with the HBA was not filled out in its entirety. The brokerage relationship was not identified in the form, and the form used was outdated. The possible violations are 1210-217-1W, 1210-217-1M, 1210-4034C, and Rule 6.22. Disciplinary recommendation is a final agency order, public censure, revocation, a fine of $7,500. And we're also recommending that this is a direct referral to the Attorney General's office. And Investigator Hardy is here if you have any questions.
Great, thank you. Any questions or discussion on this case?
I guess refresh my memory. The commission voted twice, I think, prior to revoke the license. Is it their license is still active? Is it because it's still those prior stipulations are in litigation, or?
That's correct. Correct, commissioners. When you vote to take action on a license, The licensee has the opportunity to accept that discipline when the case goes to ESP. But if they do not, the case is referred to our office and our office pursues it. And at that point, the discipline does not take effect until we have either a settlement or until we have a final agency order. And that is something that we will talk a little bit more about in executive session during your legal training. But in this case, that is what's happening, Joe. You're absolutely right.
Any other questions? Seeing none, may I get a motion?
Sure. In investigative matter U, I move that we accept staff's recommendation of final agency order, public censure, revocation, a fine of $7,500, and a direct referral to the Attorney General's office.
Thank you. Do we have a second?
Second.
Thank you. Any further discussion? All those in favor?
Aye.
Any opposed? Motion passes as presented.
All right. Investigative matter V is complaint, two complaint numbers, complaint 2022-748 and 2022-750. The division received two complaints, one from the listing broker and one from the seller of the home for sale. The respondent was representing the buyer who was under contract to purchase the subject property. The complainants alleged that the respondent did not understand the contractual mechanism of the inspection objection and inspection withdrawal, which resulted in the buyer's contract terminating. The respondent presented an inspection objection on behalf of the buyer. The listing broker presented an inspection resolution, which did not correct all the items in the objection. The respondent texted the listing broker and stated that the buyers wanted to terminate the contract. The seller withdrew the inspection resolution before it had been executed and signed an offer which was placed in second position. The listing broker notified the respondent that the seller was moving on to a backup offer, but waited until after the inspection resolution had expired before moving the backup into first position. The respondent failed to withdraw the inspection objection prior to the inspection resolution deadline. Had she done so, the buyer's contract would have stayed in force. Possible violations are 1210-217-1Q and 1210-405-1B. The disciplinary recommendation is coursework in contracts, a fine of $1,000, and diversion. And Investigator Hardy is here to answer any questions.
Questions, discussion? Seeing none, may I get a motion?
I motion that in commission matter V, that we accept staff recommendation, disciplinary recommendations of diversion, a fine of $1,000, and coursework in contracts.
We have a second.
Second.
Thank you, Graham. Any further discussion? All those in favor?
Aye.
Aye.
Any opposed? Motion passes as presented.
Right. Investigative matter W is complaint number 2022-1746. On September 1st, 2022, the respondent pled guilty to assault 3, no reckless cause injury, a class 1 misdemeanor, and was sentenced to 2 years probation. The criminal charges are a result of a domestic dispute that happened on February 22nd of 2022, in which the respondent physically assaulted his wife. The possible violation is 1210-217-1N, and the disciplinary recommendation is diversion, a fine of $250, and probation that is concurrent with the criminal probation. And Investigator Coates is here to answer any questions you may have.
Thank you. Any questions, discussion? Seeing none, may I get a motion?
I motion that in commission matter W, we accept or approve disciplinary recommendations of diversion, a fine of $250, and probation concurrent with the criminal probation.
We have a second?
Second.
Thank you. Any further discussion? All those in favor?
Aye.
Aye.
Any opposed? Motion passes as presented.
Investigative matter X is complaint number 2022-1919. On October 11th of 2022, the respondent pled guilty to promotion of obscenity to a minor, a class 6 felony. Possible violation is 12-10-217-1N. The disciplinary recommendation is diversion, a fine of $250, and probation that is concurrent with the criminal probation. And Investigator Coates is here to answer any questions.
Thank you. Any questions? Seeing none, may I get a motion?
I motion in commission matter X that we approve staff recommendation of diversion, fine of $250, and probation concurrent with criminal probation.
We have a second.
Second.
Thank you. Any further discussion? All those in favor?
Aye.
Aye.
Any opposed? Motion passes as presented.
Investigative matter Y is complaint number 2022-1989. On September 26, 2022, the respondent pled guilty to identity theft, a class 4 felony, and received a deferred judgment and sentence. The respondent is currently serving 2 years probation. The charges and guilty plea are a result of the respondent writing approximately 11 checks from her former boyfriend's business account. Possible violations are 12-10-217-1N, 12-10-217-1P, 12-10-217-1M, and Rule 6.23. Disciplinary recommendation is diversion, a fine of $500, and probation that is concurrent with the criminal sentence. And Investigator Coates is here to answer any questions.
Great. Any questions or comments on this? Seeing none, may I get a motion?
In investigative matter Y, I move that we accept staff's recommendations of diversion, a fine of $500, and probation running concurrent with criminal sentence.
Do we have a second?
Second.
Thank you. Any further discussion? Seeing none. All those in favor?
Aye.
Aye.
Any opposed? Motion passes as presented. And that wraps up our complaint investigations and audits. So do you guys want to take a 10-minute break before we move on?
That would be great.
Okay, I'm showing 10:30, so about 10:40 we'll come back and finish up.
Sounds good.
Thank you. All right, are we all back? Renee, are you with us? All right, looks like we are all back. We are moving on to licensing matters.
The first is licensing matter A, complaint number 2022-1671. On 9/20 of 2022, the applicant submitted an application for an independent level real estate broker, individual proprietor. The applicant disclosed that he was previously licensed in Colorado as an employing level real estate broker. During the investigation of the applicant's previous license history, it was found that the applicant signed a stipulation and final agency order on January 1st of 2008, wherein his broker's license was suspended for 90 days. Additionally, he was assessed a fine in the amount of $2,500, 12 hours of education, and public censure. The applicant completed the terms of the stipulation. Again, on July 2nd of 2012, the applicant signed a stipulation and final agency order wherein his real estate broker's license was revoked. The applicant was also assessed a fine in the amount of $7,000 and public censure. That fine has been paid in full. This was presented at your last meeting in December, and we deferred it to this meeting because you wanted to see letters of recommendation from the applicant, and he did provide 5 letters of recommendation. And we do not have a recommendation, but Investigator Gabarty can answer any questions.
You said he did submit 5 letters of recommendation?
Correct, yes.
I don't know if I'm not seeing it. Does anybody else see the 5 letters?
They're all in-
I see one.
They're all in the same document.
Oh,
Yeah.
okay. Okay,
Got
thank
it.
you.
Thank you.
I did see the one and then I was,
Yeah, I just,
okay. All right,
I'm
do
so
we
used
have,
to things coming in separate documents.
right? Do we have a motion on this?
Sure. In licensing matter A, I move for approval.
So if I can interject, if we do approve, I would recommend we approve for an associate level, not an independent.
And that was the discussion you had last meeting.
Yeah, I'm still concerned. I'm still not confident in terms of the first stipulation. It's basically, he wants to, lack of better words, recreate what he was doing then, which is representing himself with these new builds, building developments. And I don't see him addressing what happened back then. So again, if we do approve, I'm okay as long as it's not an independent level.
Got it. Okay, I can go along with that.
And we can stipulate, I believe, how long.
He's the principal of the business though. So how would he be?
He'd have to be supervised under a brokerage firm.
Right.
So technically, since he's principal of the business, he doesn't actually need a license to sell. He can't list it on the MLS, but he doesn't actually need a license to do business.
So then the question would be why? Why do you want a license?
Well, he'd be gaining the ability to list it on the MLS.
Yeah, and that might be why, to cut out the middleman.
Well, and none of these letters of recommendation are really, they're not on letterhead. They're not.
Commissioners, if I may, 4 of the 5 recommendation letters I did verify.
Okay. Well, I mean, we can still approve with that associate broker, and then he can do what he chooses to. But we could definitely extend that time longer than the 2 years.
I would recommend 5 years.
Commissioners, any other discussion? So Renee, is your thought maybe we don't approve because he's already a principal, or you just are just putting that out as a thought?
I honestly would go the other way, that we do approve it so that he's under being held accountable.
Okay. All right, Joe, would you like to make a, yes, Angela?
We have a motion on the floor. It's Graham's motion to approve the license unless he wants to amend or withdraw that motion.
Oh. Graham, you're muted.
I will withdraw my, I do want to withdraw my motion for full approval.
Okay. Joe, would you like to make a motion?
Sure, I motion in licensing matter A to approve the applicant for an associate level license for 5 years before they can. Wow, that was bad. Sorry, let me start over. In licensing matter A, I approve the applicant for associate level license, minimum of 5 years.
All right.
Can I
Angela.
stop and just ask the division, given this applicant's prior history, normally an associate broker has 2 years of high supervision. I don't know if that will be the case unless you specifically ask for that. And I'm not sure that that's what you wanted, Joe, as opposed to just having the associate level license with reasonable supervision.
Reasonable supervision. So it would be high level for 2 years, and then beyond that would be reasonable level. Would he automatically have high level supervision for the first 2 years?
So if you issue a broker associate level for the first 2 years, they're required to have the high level of supervision.
Okay.
After 2 years, just based on the license law itself, that's when they're able to either go to independent or take the steps to become an employing broker. So if you want them to stay at the broker associate level for longer than 2 years, then it's considered a restricted license. And he would need to sign an agreement saying that, and within that 5 years, if you want them to have a high level of supervision for the entire 5 years, you can make that a stipulation as well.
Okay.
We just need the direction.
Okay. So I would recommend a restricted license for 5 years. Whether or not it has to be high level supervision for those 5 years, I don't know.
So is it a question you're asking the commissioners to weigh in on?
I guess so. My concern is I don't want him to automatically, apply for an independent or employing broker level just based on the past history.
Right. Yes. Yeah. So then I think that motion would look something like approval of a broker associate with restricted license for 5 years. So if you're only leaving the high level for 2 years, then I think that you don't have to address it for the additional 3.
Okay.
But I could be wrong. But if I am, Marsha or Angela will weigh in.
I will
No.
write down high level of supervision for 2 years, and then the other 3 years would be the regular level of supervision.
Perfect. All right, Joe, one more shot at making this motion.
Okay. I'll get it right eventually. In licensing matter A, I move to approve the applicant for restricted associate broker license for 5 years.
Thank you. Do we have a second?
Second.
Thank you. Any further discussion? All those in favor?
Aye.
Aye.
Any opposed? Motion passes as presented by Commissioner Chang, because I'm not going to try to recap that. Thank you.
Thank you.
All right, licensing matter B is an application. It's complaint number 2022-2233. On November 14th of 2022, the applicant was convicted of theft of $20,000 to $100,000, a class 4 felony, and theft of $1,000 to $2,000, a class 1 misdemeanor. The applicant was sentenced to a 2-year deferred judgment and sentence on the felony count. The applicant is ordered to pay restitution in the amount of $137,316 and made a $50,000 payment as provided in the plea agreement. That plea agreement required a $50,000 payment. There is no recommendation as usual, and Tabitha Quintana is here to answer any questions.
It looks like we're missing information. Is that because the prosecution is still ongoing?
What information?
There just doesn't seem to be enough information about what actually happened. And I know they said some of it was because it was still ongoing. Do we have all the information?
She's on a deferment for 4 years.
Are you just talking about the
case itself and what she is claiming and what actually happened? And it just doesn't seem like there's a lot of information about the case. Plus, there's also still a balance owing of the $87,000.
I'm just looking here. So it looks like, yeah, we have the complaint from the court, which was the charges. And yeah, kind of based on that, I think that that's all that the applicant was able to provide. And then she provided her explanation as well. But I see what you mean, that there's not a ton of detail about what occurred.
No.
Well, the form from the police department said that they can't release it because the request was denied because the case is still ongoing. Is that because it's
it could be, yeah, if she's, I mean, every department seems to be a little different, but in this case, yeah, she is on that deferred sentence and judgment. So at the end of that 4-year period, the case can be, just completely dismissed if she upholds all of her probation. So that could be a reason why they were not releasing it.
Well, this is not a small crime.
No, when is the balance supposed to be paid? I know the $50,000 was paid last month, but when is I didn't see when the balance was actually supposed to be paid.
Part of her probation, it looks like, or the deferment.
So in the next 4 years. Usually they put them on a payment plan, which would be usually before they would defer the case.
So, I mean, at the moment, it doesn't seem like we have enough information. And I know it's on a 4-year probation. So I would say no at this point.
Is there any more information? I'm just trying to think, like, is it just you think we won't ever have enough information just because we don't have that police report? Just more time needs to pass?
I didn't feel that there was enough information about the case, about what she said happened and about what actually happened and how the theft occurred. And how is that theft tied to the car, etc.? There were quite a few details I thought were missing.
That was very confusing. Yes, the explanation was very confusing. I couldn't follow it. Honestly. Commissioners, any thoughts?
Yeah, because the prosecution of the case is still ongoing, it doesn't feel like things have been settled.
It doesn't feel like we can make a decision right now.
Yeah.
Right. And, I do want to thank, the applicant for, all the personal statements and, the written letter of recommendation. But, I just kind of need to second, third, and fourth, what all the other commissioners have said, that I just don't think now is the time to really make a judgment, or we don't have enough information as well.
All right. So does someone want to make a motion? And I believe Angela or Marcia is going to ask for our reasoning behind that. So we do need a motion.
So I motion in the application for licensure B that we deny it at this point in time due to lack of information, as the prosecution is still ongoing and we don't have all the details in the case. She is welcome to apply later, but we would need more information, and maybe that would be after the prosecution is complete.
Thank you, Renee. Do we have a second?
Second.
Thank you, Graham. Any further discussion? All those in favor?
Aye.
Aye.
Any opposed? Motion passes for denial of licensure.
All right, Commission Licensing Matter C is complaint number 2022-2043. This is an application. On July 21st, 2022, the applicant was convicted of sexual contact, a class 1 misdemeanor. The applicant was sentenced to 5 years of probation and a fine of $5,161.50. The applicant's probation is ongoing and set to end on September 22nd of 2027. Applicant has a current balance of $5,161.50. There's no recommendation, and Tabitha Quintana is here to answer any questions you may have.
Did this application come before the commission before? I'm just curious, because the letters of recommendation and the personal statement are dated December 2021.
Not that I'm aware of. This is the first time that it came across for me.
Okay.
I can look quickly here just to confirm. It looks like, so they did apply in 2021, but they did not, you didn't see it. They did not provide enough information at the time for it to even make it to the commission for a decision. So the application was withdrawn. So that's probably why.
Thank you.
It was kind of confusing about the employment because it looked like he worked for the employer for a while and then left and now is going back. Is that correct? He's going back to the same place?
Let me take a look. Just one
Looked
moment.
like he worked there he left in, I think, January of 21. And now they're saying he's going back. And he also hasn't paid any of the fine.
Yes, that's what it looks like. He is going back to the same place. And he does still have the current balance.
Oh.
So if we approved, would his license automatically be on probation with? How does that work if he's still on probation through 2027? Just
You,
Yeah, 'cause-
you can ask for it to be on probation through 2027, just that he'd have to report any maybe new arrests or anything like that.
It seems odd to approve an application and put it on probation immediately.
Commissioners, I'll add that sometimes you do that, but sometimes also you look at the fact that an applicant is still on probation or they haven't paid their fines, and you consider that an aspect of rehabilitation in that they are not rehabilitated such to deserve applicant status. So I've seen it both ways, and it's for you to decide.
Yeah, I'm really struggling with, the ongoing probation and the outstanding balance. As you know, it just sort of seems I would be leaning towards recommending a denial or a negative opinion at this point, just due to that. But I do see why we would want to approve with high level of oversight and probation. So.
Well, I think we'd also want newer letters of recommendation.
And commissioners, so it's another type of restricted license if you do grant it and he's on this probationary status until he completes his sentence, just so that you're aware, it's considered a restricted license.
Yes, I think the only letter I see that's current was from December from a employing broker. The rest of them are older. Does somebody want to make a recommendation? No one?
Well, I recommend that in application for licensure, letter C, that we deny the application at this time.
We'll need to give a reason.
The fine has not been paid, and he still has multiple years of probation left. And the letters of recommendation need to be more current.
All right, thank you. Do we have a second?
I second.
Graham. Any further discussion? Hearing none. All those in favor? Aye.
Aye.
Any opposed? Motion passes for denial.
Licensing matter D, is a preliminary advisory opinion. It's complaint number 2022-2183. In February of 2013, the applicant signed a stipulation to voluntarily surrender her Colorado real estate broker's license, and that was in lieu of revocation. The applicant has met all terms of the stipulation and did recently pay the fine for her violations in full to the commission. There's no recommendation, and I was the investigator and can answer any questions.
That fine was paid like right when they, like literally right before they did this, right?
Right, yeah, in order to apply, the fine had to be paid. And that fine, I just want to make it clear, is that goes to the division, just strictly for, the license law violations.
And commissioners, if I can just, this is Penny, I'm sorry, I'm still having camera issues. If I can just make one clarification. She did sign a stipulation that referred to a voluntary surrender, but it was treated the same as a revocation. It wasn't in lieu of a revocation. Her license was revoked. She just voluntarily signed that stipulation, and sometimes that language is used, but it's the same.
Thanks, Penny. Yeah.
And I think her license in the other state is inactive, correct? I thought I read.
Have to triple check that.
So what she's doing right now is working for builders, and she does not have to be licensed for that position. She's unlicensed and she's doing very well. I'm not sure why she wants her license now.
Well, in her letter, that's where it's coming from, Sarah, is the applicant actually said, my license is currently inactive.
Okay.
In South Carolina. But doesn't say why.
I commend the applicant for the success they've had in the sales area of what Renee just mentioned, with builders, but I'm still stuck on the events of what happened with the prior stipulation. I don't see a direct explanation of what happened. And I was still concerned of why she had the properties all quit claimed into her company. It just does not sit with me well. So for that reason, I would issue a negative opinion on this applicant.
Would you like to make a motion?
Please do it, Joe.
In licensing, would be considered licensing letter D. I motion for a negative opinion.
Second.
We'll have to give a reason.
I don't think you need to with a.
We don't with preliminary.
No, you don't have to worry about it. Just the license denials.
Okay, thank you. All right, and then we thank you, Renee, you seconded. Any further discussion? All those in favor?
Aye.
Any opposed? Motion passes for a negative opinion. Penny, we are on to you for ESP matters.
Okay, and again, I apologize for the camera issue today. I do look the same. I do actually look like I've gotten younger rather than older, so.
So you're not wanting to flaunt it? Is that what you're saying?
Don't want anybody to feel bad. Anyways, the first complaint matter is number 2021-1953. This is a matter where an individual signed a stipulation and has not completed the terms of it. Now, I discovered this late, that there's some of the materials, the end of the page is cut off a bit. And there's some materials missing from my next matter as well. So I'm happy to kind of walk you through that, or if we need to pull them for you to, have the full packet of information for the next meeting. The issue with this particular individual is that there is assigned coursework that has not been completed, and they remain active. They are currently working as an independent. I believe this says that they are an EA, but that is incorrect. I believe they're an independent. And so because we can't seem to get compliance on the coursework and education, we bring it back to you with the recommendation of a final agency order, a public censure, a fine of $2,500, in addition to them complying with the outstanding coursework. And I will attempt to answer any questions that you might have.
All right. Any questions for Penny? No. Can we get a motion?
I motion an ESP matter A that we approve the fine of $2,500, the FAO, final agency order, public censure, and coursework.
All right. Do we have a second?
Second.
Thank you. Any further discussion? All those in favor?
Aye.
Aye.
Any opposed? Motion passes for fine up to $2,500 for CREC, final agency order, and public censure.
And coursework.
And to complete the coursework from the previous stipulation. Yes.
And to complete the coursework. Yes, thank you.
Okay. All right. The next matter is 2021-725. This individual signed a stipulation back in June of 2022. It was for a continuing education audit. They were required to take the makeup coursework. At the time, there was no fine imposed. And unfortunately, they've done some of the coursework. There seems to be 3 remaining hours of contracts that we have been unsuccessful in gaining compliance. And again, this individual remains active, is an employing broker level. So I don't have an employing broker I can reach out to help gain the compliance. And so we are bringing this to you with a recommendation of a final agency order, the public censure, the $2,500 in fine. And again, the requirement that they comply with the remaining coursework for the previous stipulation.
All right. Any questions? Seeing none, can I get a motion?
In ESP matter B, I move that we accept recommendations of a fine of up to $2,500, final agency order, public censure, and the coursework from the prior signed stipulation.
Great. Do we have a second?
Second.
If I can add one clarification before you vote, I'm sorry. I know the memo says the fine up to $2,500. It was intended to say $2,500.
Okay.
So.
All right, I will amend to say in ESP matter B, I move that we accept staff's recommendation of a fine of $2,500, final agency order, public censure, and the coursework from the previously signed stipulation.
Second.
Thank you. Any further discussion? All in favor?
Aye.
Aye.
Any opposed? Motion passes.
Okay, thank you, commissioners. That's all I have for you today.
Thank you. And we do have to go into executive session for Attorney General matters, so I will read that.
Commission Chair, while you pull that up, just for any members of the public, the commission will be in executive session for the last portion of the meeting, and they will return just to adjourn the meeting. But I believe your public business has been concluded at this time.
Great. This is Commission Chair Michelle Espinoza. This is a real estate commission meeting on February 7th, 2023. And the time is now 11:16 a.m. I move that the commission enter into executive session pursuant to Colorado Revised Statute Section 24-6-4023A2 for the following purpose: to receive legal training from our general counsel along with an overview of cases handled by the Attorney General's office in 2022. Can I get a second?
Second.
Me? All those in favor?
Aye.
Aye.
We will now enter into executive session.
And commissioners, if you could leave the public platform or at least mute it and turn off your camera so we don't have any bleed over. There is a separate link that you'll use for executive session, and I will see you there shortly. Thank you.
All right, looks like we have all commissioners back. Thank you so much. It is 12:07 and I am adjourning this commission meeting. We'll see everybody in April. Thank you so much for joining us today. Have a great day, everybody.
Thank you.
Thanks, you too.